Good evening, everybody, and welcome to the special session meeting for August 22nd. It is 5 o'clock. I call this meeting to order. May I have a roll call, please?
Mayor Orndorff.
Here.
Commissioner Hewitt.
Here.
Vice Mayor Suey.
Here.
Commissioner Watson.
Here.
Commissioner Romanek.
Here.
Stand for the salute of the flag, please. I pledge allegiance to the flag
of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
This meeting is being conducted in accordance with the Open Public Meetings Act of 1975, was advertised, posted, and made available to the public as required by statute. The municipal clerk is directed to include a statement in the minutes of this meeting. Madam Clerk, are there any changes to this agenda?
Yes, Mayor, we had two. The first was the removal of ordinance on second reading, item 3, per Vice Mayor Suey. There will be a presentation on this project at the September 5th meeting and will be included on that agenda. The second was the addition of resolution number 1, authorizing an ingress easement agreement with Atlantic City Electric on Kates Boulevard.
Thank you. Okay, public comment on agenda items only. If anybody has a comment on agenda items for this session, if I'm correct, Solicitor?
Right.
Yes.
Please come to the podium, state your name and your concerns. Please limit those comments to 5 minutes. Seeing nobody, we will close the public comment on agenda items only and move to ordinance under the second reading, please.
Okay, we have an ordinance releasing, extinguishing, and vacating the rights of the public to a portion of certain paper streets and rights-of-way located in the city of Millville, known as Mickle Street.
Make the motion on ordinance in the second reading.
Second motion.
I have a motion and a second on item number 1. There's a public hearing. If anybody has questions or concerns on this ordinance, please come to the podium, state your name and those concerns. Seeing nobody, we'll close the public hearing. Any comments of commissioners? Roll call, please.
Commissioner Hewitt.
Yes.
Vice Mayor Suey.
Yes.
Commissioner Watson.
Yes.
Commissioner Romanek.
Yes.
Mayor Orndorff.
Yes.
Motion carries. Second item is a bond ordinance authorizing various capital improvements and acquisitions appropriating $500,000 to pay the cost thereof, to authorize the issuance of $475,000 of bonds to finance the appropriation, and to provide for issuance of bond anticipation notes in the anticipation of the issuance of bonds.
Move the ordinance on second reading. Second motion.
I have a motion and a second on item number 2. There is a public hearing as well on this item. If anybody has any questions or concerns, please come to the podium, state your name and those concerns. Excuse me. Seeing nobody, we'll close the public hearing. Any comments of commissioners? Roll call, please.
Commissioner Hewitt.
Yes.
Vice Mayor Suey.
Yes.
Commissioner Watson.
Yes.
Commissioner Romanek.
Yes.
Mayor Orndorff.
Yes.
Okay, motion carries.
Let's move right to resolutions, since there's no ordinances on the first reading.
Okay, we just have a resolution authorizing the city of Millville to enter into an ingress-egress easement agreement with Atlantic City Electric.
Move the resolution. Second motion.
A motion and a second on resolution item number 1. Any comments? Roll call, please.
Commissioner Hewitt.
Yes.
Vice Mayor Suey.
Yes.
Commissioner Watson.
Yes.
Commissioner Romanek.
Yes.
Mayor Orndorff.
Yes.
Okay, motion carries.
Okay, public comment portion. We have now reached the public comment portion of our meeting. Anyone who'd like to address the commission, please go to the podium, state your name, address, and concerns. Please limit those comments to approximately 5 minutes. Seeing nobody, we will close the public comment portion for this meeting. Any closing comments of commissioners? Don't all speak at once. Okay, thank you. And we just need a motion to adjourn this meeting.
Make motion.
Second motion.
All in favor?
Aye.
Okay, we'll see everybody at 6 o'clock.
It's,
Or-
directly after, so if you want
Do you want to go right into it?
I think that Mr. Norman is here now.
Yes.
So why don't we let him?
Do you want to allow a few minutes? or-
Yeah, it's up to you.
We just finished the first meeting.
Are we gonna recess
Mr.
5
Norman,
minutes?
I handed a transcript
We're adjourned.
to each of the attorneys, and since you weren't here, I gave it to Mr. Tom.
Okay.
Self-explanatory.
Okay, thank you.
Do we want to start? Do we want to allow him some time? Or
Do you need a moment?
do you
to
need a
get
moment
yourself
to
situated,
chat
Mr.
beforehand and
Norman?
situate, or were you ready to
we're ready to go. No, I'm ready.
You sure?
Oh, okay. All right. So, starting here at 5:05, this is hearing for an appeal made to the Board of Commissioners concerning approved D variance on Block 416, Lot 12 for Richard Abbott versus City of Millville Zoning Board of Adjustment and our future first to be held on today, August 22nd at 2023, immediately to follow the 5 o'clock special session here in the chambers. I'm going to call this meeting to order. Just have a roll call, please.
Mayor Orndorff.
Here.
Commissioner Hewitt.
Here.
Vice Mayor Sui.
Here.
Commissioner Watson.
Here.
Commissioner Romanek.
Here.
This meeting is being conducted in accordance with the Open Public Meetings Act of 1975, was advertised, posted, and made available to the public as required by statute. The municipal clerk is directed to include a statement in the minutes of this meeting. Madam Clerk, would you?
Okay, so, the first item is a legal argument of our future first on the threshold issue of timeliness.
And Mr. Norman, that's you.
Okay. Well, is there a place?
That probably is your
Raise
best
mic.
bet.
Thank you for letting us be the first public hearing for this evening. I know there was a second special meeting. The statute, the municipal land use law says that an appeal of a zoning board's grant of a use variance must be filed within 10 days. And there's no enlargement period as there is with other provisions that you deal with land use. Typically filing lawsuits, where you file lawsuits, there's a 45-day right of appeal, subject to enlargement if in the interest of justice. There's no such provision of enlargement. There's no discretion. It's 10 days. The hearing before the zoning board was on December 2nd, 2022. Mr. Abbott was present with his legal counsel for the entire proceedings from my review of the transcript. Mr. Abbott participated fully at that hearing. He was aware of the decision at the end of the meeting, and essentially he was on notice of the board's decision on December 2nd. Now, the resolution was adopted January 10th, and perhaps he would want to review the resolution to figure out what it says, but he knew the outcome, and if he was going to make preparations to appeal to the commissioners regarding the decision, that preparation should have been made early. As I understand it, I believe his counsel, who's now the zoning board solicitor, submitted an RFP for the zoning board solicitor position in November 2022. As an attorney who practices for municipalities, many municipalities, if I have that issue of representing private clients and a municipal board in the same town or a prospective municipal board, I've got to make preparations for the transition for when that happens, because there's statutory deadlines under the municipal land use law, and I have to make sure my clients' interests are put first and that any time deadlines are met for filing any appeals or whatever. And I can give you a parallel situation to this. This was also in I believe it was this county. It was in Mantua and Gloucester County. The situation was there was a request for a zoning interpretation for a marijuana cultivation facility in Mantua Township. And it was filed for a zoning permit with the zoning officer. And the zoning officer in Mantua, they just happened to have one retiring and a new one came in. And the new zoning officer was sort of learning the ropes, and as he took the position, the appeal came, and by statute you have 10 days from receipt of the zoning permit application to make a decision on it. And if the zoning officer fails to do so, it's basically a zoning permit is automatically issued. And what happened was the new zoning officer was trying to get in contact with the municipal solicitor for some legal guidance as to how to deal with this marijuana grow. And within the time period, the 10-day period expired, so there was all kinds of equitable reasons for the town to argue that the 10-year period should be enlarged. It went to Judge Eastlick at the Superior Court in New Jersey, and just by parallel analogy, there was no period of enlargement from the 10 days. Basically, the Superior Court ordered a zoning permit for a marijuana grow based simply on inaction on 10 days. And by parallel extension here, the statute says 10 days, no enlargement, there's no discretion. It's 10 days. And the 10 days started to run from January 10th and expired January 20th. And quite frankly, the appeal was filed on January 30th, so it was filed 10 days late. But as I indicated, even if you were, for sake of argument, to consider equitable arguments, you know, the attorney was leaving the position as representing the private client to switch hats to become the zoning board attorney. You have to make preparations for that, and part of the preparations was that attorney should have notified Mr. Abbott to seek counsel, because there's a good chance I may not be able to represent you. And if you wish to appeal, you need to start preparing for that now. And it wasn't like a surprise where he only had 10 days to make the decision. The fact is the zoning board approved the use variance on December 2nd. On December 3rd, if I'm representing that private client, Mr. Abbott, I'm telling him, you need to make, if you wish to appeal this decision, you got to start making plans for that, because you only have 10 days to do it. And that means that if I'm not there, you got to find someone else to file the appeal on time. So that's my argument on the that you do not have jurisdiction to hear this appeal. Are we just addressing that issue first?
Yes.
Okay,
and
that makes sense.
I had a question for you. You've already been to Superior Court because Mr. Abbott at one point filed a complaint, low prerogative writs, and that
Correct.
complaint was filed in a timely way. Is that correct? Do you acknowledge that?
Yes.
Okay. And at that hearing, isn't it true that you made the same argument to Judge Telsey, where you said that there's no basis under the municipal land use law or under the ordinance or otherwise to grant relief from the 10-day requirement that I guess is contained in section 17, and yet the judge ruled that issue would have to come back to this governing body, and they would have to make a determination, and then it would then, if there was an appeal taken, go back to him. Is that in essence what the judge said?
Yes, I would legally interpret what the judge did is this was already filed, take care of it first. I don't want to have piecemeal litigation. I don't want to have to try one issue and then another issue, finish everything at the administrative level before you get to the Superior Court. So first, you as a commission commissioners need to decide if you have the jurisdiction. I don't think the judge made a determination substantively on
I would agree with you. I'm not
Yeah.
trying to insinuate that he
Yeah.
did. But, isn't it also the case here that even if the board, or let me put it this way, no matter what this board does, this case is going to go back to Superior Court. Isn't that a pretty fair assumption to make?
Well, I cannot speak for Mr. Abbott and what action he would take, but I would, if my client's use variance gets affirmed, we've got nothing to appeal.
But Mr. Abbott would, and he already filed a prerogative writ application that was denied without prejudice, so.
I understand what
Yeah.
you're saying, and yes, sometimes the municipal agency
Yeah.
gets caught in the middle of two sides, and they're damned if they do, damned if they don't. I mean, that happens sometimes.
Yeah,
They're
and-
gonna get litigation. That's just the
Yeah.
way it is.
And if it does go back to Judge Telsey, I think it took 5 or 6 months for the case to get before him for a hearing and for him to make a decision. So if it goes back to Judge Telsey, then you're talking about a delay, further delay of perhaps 5 or 6 months. Would you agree with me on that?
No. If the ruling is adverse to my client, we're going to file an order to show cause. And I don't mean that as a threat.
I didn't hear,
We're
can you
just
repeat what you said you were gonna file? I'm sorry.
file an order to show cause, a new complaint with an order to show cause for an expedited hearing date, because there's already, this project has already been delayed for months as it is, and we need an expeditious decision. Not because my client has any ill will to the city, that we just want a determination quicker.
And that would be something that would be discretionary with the judge, whether he would grant it. And I think he already gave, I think, both attorneys kind of a blueprint as to how the case should proceed, because he wanted Millville in the first instance to decide these issues, the issue of timeliness, and if necessary, the issue on the merits, and then the case would be ripe to go back before the judge. Would that be a fair surmise of what his ruling was?
I'd say that's a fair characterization of how it was framed, but I think legally, if you reach a conclusion that it's out of time, it's moot. Everything is moot as to the appeal itself. So
So
could
you
make
don't
that
think
ruling.
you don't think Mr. Abbott would
He can
have
appeal that, but
and then
that's-
you'd be stuck until that appeal was resolved. Isn't that true?
Well, if he files the appeal, we're going to move for a quick summary judgment.
Yeah.
It's a question of law. Is it a 10-day period to file the
Yeah.
appeal? It's a real simple issue.
Yeah.
So it wouldn't require an unduly lengthy period of time.
But all these cases, these prerogative writ applications, they're all summary actions. They're all cases where, in essence, what happens is that the judge asks for a briefing schedule, attorneys submit briefs, and it still takes a long time for the case to get decided. At least in my experience, I've been doing it for 30 years.
Well, if we file the complaint, 30 days to file an answer, we could ask for a management conference. Judge, you got one simple issue, which is the 10-day filing period. That's just a question of law. That doesn't require any heavy lifting from a legal standpoint.
Yeah, but even if the judge agrees with you and disagrees with whatever, or agrees with whatever decision this board made, there's still a timely prerogative writ application that the judge would have to hear, and that can't be heard on an expedited basis, can it?
I'm sorry.
Well,
I'm
my
not
point is
understanding
that,
the question.
there are two periods of repose in this case. There's a 10-day period of repose to take an appeal directly to the governing body,
Right.
but then there's also a 45-day period of repose to file an action in lieu of prerogative writs challenging the action of the Board of Adjustment, and you've already said that was timely, so wouldn't the judge have to decide that issue too?
Well, it's.
I mean, if he finds, suppose the judge finds that the appeal that Mr. Abbott made to this board was untimely,
Yes.
doesn't he then have to decide the prerogative writ application? That's all I'm trying to.
I believe if you file it out of time, your case is going to get dismissed in its entirety. It's
But he
like,
filed the complaint in lieu of prerogative writs within 45 days of the date of publication, didn't he?
yeah.
Yeah.
right,
Okay.
Okay.
That's my only question.
Okay. Okay.
Does anyone else have a question of Mr. Norman
I'm
on
looking at the-
timeliness?
I'm looking at the transcript from the judge, from the court case. And, basically, what it says is, it basically says that we've agreed to hear it in this decision. And I can get you the line number, whatever, if you guys want to look it up. But it also says basically after all this is done, then everybody can file their appeals, as you just said, and it basically is going to start over again. And I guess he's kind of urging us, he wants to know our logic, let's say. So I don't see any prejudice either by the city, this is Judge Telsey, entertaining, this is page 12, line 20. I don't see any prejudice either by the city entertaining this appeal and placing its rationale on the record. All the parties have the same right to challenge the city's determination once they have the ability to make that determination. So it kind of looks like he's telling us to make a determination and then have them
Wait,
appeal as necessary.
but I don't think the judge ruled that you have to grant the 10-day extension because he said wrap everything else up with it. I think they're separate. They're discrete issues.
I'm not disagreeing with you.
Yeah.
So, and then it says count 2 is a prerogative writ. And this is page 13, line 6. And because that too, because of, is premature. If the city entertains the appeal, the city is going to take whatever action it wishes to take on this appeal, which ultimately can make count 2, the determination on a zoning application, moot. So again, the city has to be given the opportunity to be heard on both of these. Basically, it's kind of looking like he wants us to exhaust all our administrative remedies before he hears it again on whatever you guys appeal. If either one of you guys appeal. I'm not sure about the 10 days because you're talking about 10 days, but he also filed the writ within the 45 days that it's necessary for him to appeal to the court instead of to the city, and the judge said let the city hear it first. That's how I'm interpreting. Am I wrong in that interpretation?
Well, I think that procedurally right now, we're dealing with whether or not he filed a timely appeal to the governing body within 10 days. That's what we're addressing now. I just wanted to make sure that everybody understands and agrees that no matter what we do, even if we grant your request, the case isn't necessarily over if somebody challenges that and goes to Superior Court.
That's accurate. If any appeal, if Mr. Abbott challenges the underlying decision, yeah, that goes through the ordinary course. So.
Okay.
Solicitor, do we believe that if Judge Chelsea felt that the untimeliness on the city would have said something and would have still said dismiss it then, but knowing that there is the 45-day as well, he would prefer the city to hear it first, then make the action?
I don't think the judge made a determination on the timeliness issue
That's what,
one way or
I think
another.
I'm
Right.
understanding and agreeing
I
with
think he
Vice
wanted
Mayor
us,
is
now, he could have done so, but he chose not to, and I think he wanted
Correct.
the city to decide that issue first.
based on our municipal land use laws.
Well, your ordinance does follow the statute, and it says 10 days.
No, I can say that I understand that Mr. Abbott did not file correctly. His timeline was not correct with the city. However, he did file that 45-day within Superior Court. And I think that from what I'm reading and what Vice Mayor is reading is that Judge Chelsea didn't speak to that. He's speaking that we should make sure that we exhaust all administrative options, and the timeliness wasn't brought up in this. That
Well, it was, and
I don't have the transcript in front of me.
The
I know
judge-
Vice Mayor has
The
it.
judge
so-
wants us to decide the timeliness issue, and because that issue could be dispositive, that's why I asked that it be placed on the agenda as the first item.
Yeah.
Because quite frankly, if you find that the application was untimely, then you don't go on to this next stage, which would be a hearing on the merits of the application. So we need to address that first.
And my client appreciates it because it's a threshold question. We don't want to waste a whole night going over the merits of the decision itself if it's unnecessary.
If I may, I'm a little bit bewildered here also on the 10-day filing of an appeal.
Yes.
I've been through an appeal. I had to hit every spot. I had to hit every point. Because it was made perfectly clear that if I didn't, the appeal wasn't going to be heard. That's the 10-day and the 45-day. Did we, Mr. Solicitor, was there an intentional move to this 45-day period that we're talking about? I don't know.
What, if I can answer
No,
that.
they're two separate appeals. One would be an appeal to the governing body, which is only limited in one circumstance, and that is if the Board of Adjustment of a town grants a devariance because that goes against the zoning of the town, there's a special right to take an appeal only in a case like that to the governing body. And that's not only under our ordinance, but that's under the municipal land use law. The 45-day period is the period that normally applies to any planning board or zoning board decision. If someone doesn't like what the planning board did or the zoning board did, they can't go to the governing body. They have to go to Superior Court. They have to file a complaint on low prerogative writs, and they have to do so within 45 days. So that's the general rule. That's generally what you do. In this case, the objector had the option of also, or seeking in the first instance, an appeal directly to the governing body, which he did, albeit it was filed, I believe it was filed 12 days out of time by my calculation. I know you said 10, but I think it was arguably 12 days out of time. And we can hear from counsel as to his view on that in a minute. But does that clarify things a little bit?
Yeah, I was just trying to clarify in my own mind, as in being through one of these, and I never knew of the 45-day.
Right.
It's almost as if you find that the 10-day period expired and the appeal was untimely, it's as if it never came to you in the first instance. And Mr. Abbott would have a right to appeal the zoning board's decision to grant the approval to the Superior Court, and that would be the posture of it. It will be as if it never came in front of you. It would just be like an ordinary zoning challenge case.
You guys have any other questions?
And I have nothing further, and whether it's 10 days or 12 days, that's of no importance, because this, or 12 days, I'm sorry. It's exceeded the 10-day statutory period, the filing, so therefore, you know our position.
Okay, if you're finished, I'm looking at the agenda, and I think we may have left poor Miss Gardy out by accident, and I don't know who goes next. Who would like to go next? You want to go next?
Okay, so we'll add
Evening, ladies and gentlemen. My name is Jim Moore. I represent Richard Abbott with respect to this appeal. With regard to the threshold issue.
Can you move the
Can you, yeah, sorry.
Trouble hearing.
Can you hear me now?
Yes,
Is
perfect.
that a little better? Sorry, I'm a little soft-spoken. Although that's not what my kids tell me. So, with respect to the timeliness of the appeal, first I want to focus on the statute and the ordinance that governs that 10-day time frame. Nothing in the ordinance or the statute prohibits the city from hearing this appeal, notwithstanding there's a 10-day period in the ordinance. Just as there's no express permission in either the statute or the ordinance for relaxing that time period, there's no express prohibition against doing so. And Professor Cox, in his seminal treatise on zoning and land use law, speaks to this, and I cited this in the brief that I had filed with the board. Section 42-1.2, it talks about the governing body's ability to enlarge the time to appeal in its discretion. And I'm quoting, "It would seem consistent with general law that the governing body would have power to enlarge that time where it is manifest that the interest of justice so requires, on the same basis that the Superior Court is authorized to do so under Rule 4:69-6C of the Rules of Court." Professor Cox explicitly talks about this in terms of an exercise of discretion. So I respectfully disagree with counsel as to whether discretion lies with the board to consider this, notwithstanding that it may have been filed out of time. But we've been talking about the 45-day prerogative writ period under the rule and under the municipal land use law. I also addressed this in my brief. That 45-day period is triggered by a publication of a conforming notice in a newspaper of general circulation in the municipality. The notice that was published on January 10th of 2023 was not conforming because it did not advise that a copy of the determination of the zoning board had been filed in the office of the board or the municipal clerk, nor that it was available for inspection. So it's Mr. Abbott's position that that 45-day period has not yet begun to run because the only notice of publication that has been published to my knowledge is that January 10th non-conforming notice. It would lead to an absurd result if the 10-day period to appeal directly to this board under the ordinance were to have been deemed to have already lapsed when the 45-day period for a prerogative writ action hasn't yet begun to run due to that deficiency in the notice. So I think that's important for the board to consider, that although we're talking about timeframes that in our future firsts view are immutable, those timeframes haven't yet begun to run because of how the notice was published and what it says, and more importantly, what it doesn't say. I want to briefly touch on the Rickel case that I cited on page 7 of my brief, and it talks about direct appeals of use variances to the governing body. The appellate division in that case spoke of, it noted that there's a strong legislative intent to grant the governing body a substantive role in the variance process. It noted that the governing body is uniquely qualified to determine whether granting a requested variance would substantially impair the zoning ordinance or the master plan. And that broad power is not only reasonable, but consistent with the purposes and provisions of the municipal land use law. Mr. Abbott submits that this case is just the kind of case that Rickel contemplates and believes that this body is best suited to conduct that review in light of its knowledge and expertise in zoning matters in Millville, and particularly this area. So for those reasons, Mr. Abbott believes that the interests of justice do support relaxation of the 10-day time period should the board conclude that that time period has in fact begun to run, both as to the legal issues presented and to the respective equities of the parties.
I have a question.
Yes, sir.
I think I remember reading part of this treatise, and isn't there, if you know, is there a case whereby which the city doesn't publish it and the person that got the variance can publish it to make the clock start ticking?
That I don't know the answer to that question. It wouldn't surprise me if that is the case.
I
But
believe it's in the same section of the
but-
treatise. If
but-
somebody could check it.
But that, again, it doesn't appear that that's happened. We still have a non-conforming notice that's
That was
the
gonna be
only
my
one that's been
question, has there
published.
been a conforming notice filed or reported to?
Well, I think that
since?
there is a period of reasonableness that would be applied. I don't think you could wait forever under that case that council cited. Now, 12 days isn't forever, but there's some limit. I mean, even if there isn't a conforming notice, at some point, I think you would have an obligation to file an appeal. I don't know when that would be. 30 days, 60 days, but there'd be some period of reasonableness. I don't think you could wait 6 months or a year to do it. Counsel, I had a question for you.
Sure.
Mr. Norman made an argument. He said, well, you know, Mr. Abbott was present at the time of the hearing, which I believe took place on December 2nd of last year. He was represented by counsel, so didn't he have notice of the decision by virtue of that? And why should he be allowed to wait until a notice is published in the newspaper and to take action at that point? I think that was the argument.
Well, I think the rule and the ordinance, in speaking in terms of that time period beginning upon published notice, I think what it does is it creates uniformity for anyone who might be interested in appealing the decision, it doesn't necessarily depend on whether or not the person appealing it was present at the hearing. I don't think that's the consideration. The consideration is whether or not the notice was published and whether that published notice conformed with the requirements under the rule. I mean, I can't argue that Mr. Abbott wasn't present, because he certainly was, but the competing equities, as we talked about in our brief, with it was a unique set of circumstances with Ms. White's appointment as the zoning board solicitor right around the crucial time when these time periods may have begun to run. I think that that's more important, or at least warrants more consideration in terms of the timeliness of Mr. Abbott's appeal than the fact that he was present at the hearing.
Are you familiar with Judge Winkelstein's decision in Island Club condominium?
I am not.
Okay, because he cited the Toot Focus versus Joy case, which is an appellate division decision from 1963, and I'm reading from the citation by Judge Winkelstein, and I'm old enough that I remember Judge Winkelstein when he sat on the bench in Atlantic County. But concluding that an objector's personal knowledge of a board's decision did not impair the objector's right to wait for formal publication of the notice before instituting an action for review of the decision.
I would agree with that. I think that's congruent with the argument I just made. Anything else?
Any further argument, further questions?
I guess I have the question of being able to enlarge the time frame. Would that been something of council to come to us with first? They're asking for that extension on the 10 days.
Well, yeah, I don't think it works that way. I think the problem that everyone has here is that there isn't normally what we do as lawyers, when there's a legal issue, we look at the published decisions to see if the issue has occurred in another court. And then if it's not one of the published decisions, now we can look at the unpublished decisions, which are not precedential. And unfortunately, there is no case that speaks directly to this issue, whether or not a board can enlarge the 10-day period of repose. Now, there is the Island Club condominium case, and that's a case that was it was a prerogative writ application, so it wasn't a appeal directly to the board. But in that case, Judge Winkelstein looked at the court rule and really talked about procedural due process, and that is, when is it appropriate that the notice should begin to run? Mm-hmm. And I think what he discussed, if you read his decision, was that it needs to be sufficient that an interested person knows that they can go to the office of the secretary and they can read the resolution, and then they can decide whether or not they want to file an appeal. That's the way he frames the consideration. Now, albeit that was a prerogative writ case, it wasn't a case where there was a direct appeal to the board, but it would seem to me that if we're talking about procedural due process, the same principles would apply.
So council made us aware that our the public notification from the Board of Adjustment was inaccurate or not correct, which then the clock never started ticking, technically. Had the publication ever been corrected?
No, it was not, and I don't believe, and by the way, a party to an applicant could submit a notice. That is something that,
Okay,
that they don't have to,
okay.
though, but they
Okay.
could have done it. And I would think, even if nobody did that, it would seem to me that a delay would have to be a reasonable one. I think if someone waited 3 months or, and I'm just giving arbitrary times, I don't think that would be reasonable. So I
So
think.
proper notice has not been given by the Board of Adjustments and/or the applicant that this is on file with the city
The-
clerk.
The notice said that the board had adopted the resolution, which of course is what's important, because that has all the findings of fact that are, of the board's decision. And that notice did not say that the resolution was on file with either the board secretary or the municipal clerk and was available for inspection.
So it's a deficient process, that notice
Well,
that was not.
Well, at least Island Club says, in the case of a prerogative writ application, that would not provide adequate due process to someone that wanted to challenge the decision.
So how would you know what to appeal if you didn't have a copy of the decision? Is that
Well,
what
that's,
you're saying?
that's what Island Club says. If you read that, that's the analysis, that you should, as an interested party, should have the right to read the resolution and then to make a decision as to whether you want to file the appeal. You only have 10 days to do it.
So if it was somebody other than Mr. Abbott, they may not have realized the information was available.
Well, yeah, that's possible, and under Island Club, I mean, it's right in the case, and it cites an appellate division case that was reported, that even if an objector is present and has personal knowledge, he's still entitled to rely on the court rules and the notice provisions.
Just by way of brief comment, even though Mr. Abbott may have been present at the meeting and heard what was said, he couldn't have had a copy of the resolution because it wasn't adopted at the meeting. It was adopted later. So,
And typically, that, we all know, some people here might not know that, but normally what happens when a board votes on an application, there is not a resolution that gets approved at that meeting. Yeah, that happens once in a while, but it's very rare. And so typically, the resolution doesn't get adopted until the next meeting, and that's what that's what the judge is going to look at. The judge is going to want to look at that resolution. He's going to want to see if there are adequate findings of fact, and so that legal document normally isn't prepared until the following meeting. And the time doesn't run from the adoption by the board. It runs from when the notice goes out after the resolution is adopted. That's when the time runs.
Can we, I don't know how we are going to.
I would
go
let
back and
Mr. Norman, are you finished?
I'm finished.
Why don't we
now.
let
I'll
Mr.
say-
Norman have a brief rebuttal on timeliness?
Yeah, I just think there's 2 points. The first point is that Mr. Abbott was there. Now, if it was a third party that was not at the meeting, they've got some legitimate due process argument that the notice may have been deficient, and they can pose that argument. But the fact of the matter is Mr. Abbott was there. He knew the result, and he heard the conditions of approval, which are set forth in the resolution. It was not a complicated determination. He could have made arrangements to file it within 10 days. And in fact, if I was Mr. Abbott's attorney, I would assume that the clerk would not make a mistake in the notice of decision, and I would get that complaint filed timely. I wouldn't be crossing my fingers and hoping the clerk would make a mistake, and it would benefit me to allow me some extra time. I really don't. I think that's a key distinction, is that Mr. Abbott knew he had due process. He participated at the hearing. Why does he get a special benefit to appeal to the commissioners when he otherwise wouldn't? I mean, but for it's actually punitive to my client.
May I ask a question?
Sure.
Well, 2 things. First of all, did he see the resolution that night that the variance was granted?
No, the resolution wasn't adopted
didn't.
till January 10th.
Second,
But
you
he knew the outcome, and if he was vehemently opposed to the approval, he of course, before you file it, you want to see the resolution, but you put it on your calendar, and you're going to file it timely, the appeal timely.
Second, you mentioned that we would be,
I would go further to call the secretary to say, is the resolution ready? the day after the January 10th hearing, I'd ask for a copy of the resolution myself.
He's not,
I would be.
he's not required to do that, correct?
It would be legal, I think it could be legal malpractice not to do it.
Well,
To not file a timely
Second-
appeal?
My second question is, you said that if anybody else could file this appeal, it would be okay, but if Mr. Abbott files it, it's not okay, because he was there.
Yeah, because that's what due process is, did you have a right, this is the common sense side of it. These are all technical arguments. The
Yeah,
common sense side of things is, did he know of his right to appeal and was he on notice of when he had to file it? Yes, he knew.
He might
knew.
not have, he's not a municipal land use lawyer. He
But
might
had-
not have been
but he
aware.
had- But he had one. He had an attorney at the hearing who was special,
So-
who had experience in land use, and that who's now your zoning board of solicitor, and presumably she would say you need to make arrangements to file your appeal.
So, to follow up on my other question, so if anybody else that was there, or anybody that wasn't there, would have filed the appeal, it would be okay to file the appeal because they weren't there? So who are we treating special, everybody else or Mr. Abbott? That's kind of like a
It's not
balancing
a-
argument according to the court case that the counselor just brought up.
No, this is just.
Excuse me, their side comments need to stop, please, thank you.
It's just the common sense of it. The equities are a consideration in this, and there was no prejudice to him. If any deficiency, he could have gotten that resolution. I mean, when there's an important document ready to come out on January 10th, you're going to ask for it. You're not going to wait. You're not going to read a notice in the paper and rely upon it. You're just not.
Do you know how long it takes our zoning board to actually get a resolution
I was
prepared?
gonna say, was he given a
When
date
does
that
that
day?
happen? Does it happen one day after the hearing, 5 days after the hearing, after somebody types up the minutes? When does that occur?
Oh, as someone who does this, and sometimes it takes more than 30 days to get a resolution done, but the statute says you're supposed to memorialize a resolution in 45 days. So my practice is I get the resolution done by the following month. It's on the agenda. So I mean, there is a timeline for getting the resolution
Right,
memorialized.
what I'm getting at is you said he could have asked for the resolution, but he could have asked for it and it may not have been done. I don't know, and you probably don't know either, I don't know.
Well, you could ask the question, the secretary says it's not ready. Well, let me know when it's ready.
Okay, fair
Send
enough.
an email back. It's communication. Thank you.
I just have one question for you, Mr. Norman. You mentioned that there was no prejudice to Mr. Abbott. Is there any prejudice to Mr. Tom's organization if the board were to accept a 12-day late notice of appeal?
I believe so, yes.
And what would that prejudice be?
Well, the prejudice is that you have to go through a full hearing process before the commissioners, which is statutorily out of time. It increases the legal fees for my client, and it was a mistake not made by my client, but it was made by an administrative personnel of the township.
Anything further?
It shouldn't be prejudicial to my client, and it is. So.
Do you want me to sum up? Actually,
No,
I'm
you still
sorry,
have another
I
turn.
forgot about you. Ms. Gardy, you're next.
So, good evening. I'm Lou Gardy. I was appointed to be counsel for the zoning board for this matter, and I've appeared in the litigation. And not to repeat what everybody said, but let's just back up on this 10-day time frame. The 10-day time frame is a statute, and that statute is an enabling statute, which allows local governments to do certain things. And what this statute says is that if a municipality wishes to, you can adopt an ordinance which provides for the direct appeal of a zoning board decision granting a use variance, because if they did it for a denial, well, I won't get into that. But so what this is enabling legislation. And the 10-day time frame is governed by your ordinance, which says you have to file the the appeal within 10 days. But there's a difference in terms of the standard for relaxing a time frame for doing something, hitting your mark, as Commissioner Hewitt said, under a statute as opposed to an ordinance. And the learned treatise cited here, Commissioner, by some of the counsel of Cox, says that under an ordinance there is typically an allowance, because you're a local governing entity, to relax certain deadlines, and usually it's for reasons of, fairness and equity. And there are actually some cases, or I did find a case that permitted neighbors who knew of a zoning application and that it had been denied, and the resolution was not adopted in time, and the person whose application was denied 9 months later said, hey, this resolution wasn't adopted, so by default I get the approval, and then started getting the permits and stuff started happening. Well, the neighbors saw things happening. They adopted a new resolution saying, oh, poof, it's granted. And then the neighbors started objecting, and the courts found under the Lizek case, and I can cite it for Mr. Russell, or for all of you if you wish, Liza versus Faria. It's a published decision by the Supreme Court from 1984, and they said, look, the neighbors knew what was sort of going on, and they filed their requests out of time, but good reason was shown for doing so. So there is a difference in the timelines asserted here, and I do agree with Mr. Norman that the time that he set forth calculated as to when the deadline is correct. The zoning board decision was on December 2nd. The resolution was adopted on January 5th, but it was not published until the 10th. And what the courts have said, when you do a notice of decision, for example, if the board adopts or publishes a notice of decision, or when you adopt your ordinances and you you publish it, the publication of a duly noticed decision that has to include, under the statute, the provision that the document adopted is on file with the clerk or the board to make it a timely and compliant notice. That has to be indicated in the notice for a notice of decision. The ordinance is silent on that. But the Cox treatise says that you should pretty much follow what the statute says, so that it should include that notice to the public. Hey, if you want to see this resolution and take a look at it, it's on file. This did not. This notice did not indicate that. And to the mayor's point that you made before, court cases have held that if you've got a notice of decision which is defective, the timeline has not started yet. So technically, the timeline for the 10-day timeline to appeal has not expired yet because it was not adopted. And I think the mayor asked a question before, or Commissioner Sui asked before, hey, do applicants then publish the decision? And I've had that happen many times, where developers will have some type of unpopular application, and they get the resolution and they're bugging us the next month, when did you adopt it? And they get it the next day signed, and they publish it themselves, even though they may not be required to. So that does happen, to answer your question from before. So this is a jurisdictional question, and I think that your solicitor is guiding you well in terms of how to deal with this. But I would urge you to make a determination of whether it was timely or not, and then if it was not timely, whether you would find that circumstances exist to enlarge it. And I respectfully submit that it's only 6 days, because we're talking about a time frame this small. You count business days. So this was from Friday the 20th to the Monday the 30th. That's 6 business days. So the question is whether that short of a period of time should permit an enlargement. And the Faria case that I cited, the neighbors were late by several weeks, and the court found that was within discretion, their discretion to do so. So I hope that's helpful for you in weighing all of this. But I think the jurisdictional issue should be addressed.
Any questions, council?
Does he get a chance to rebut any of that?
Everything you'd like to say?
I'm asking if he should get a chance to rebut any of what you just said.
I guess I would argue is.
I'm asking, I didn't say go ahead.
Why don't we hear from him?
I guess I would suggest that if the notice was defective, Mr. Abbott did file an appeal, so he certainly knew he had to file an appeal, and if the fact that he filed one shows at least he knew about the decision, he knew about the resolution. I mean, I don't know if he spent six days wondering when the resolution was going to be on file with the secretary. I don't think he's relying upon the legal notice. I think his attorney is calling the board secretary, is the resolution ready? That's what I think.
And I have a question for you, more solicitor. So much of his argument is based on while it's not technically correct, it comes down to common sense. But I remember watching a movie, and I can't remember the movie, but it was Sir Thomas More, and they asked him, where, you're hiding behind a technicality in the law, and his answer was, where else will you hide when the devil comes for my soul? So are we supposed to make the decision based on technicalities in the law, or are we supposed to go by common sense? Or are we supposed to use both?
Well, if you want, can I answer that question generally?
Yeah, please.
And maybe sum up for us? I think what you have here is you don't have a case that is specific to this issue. There just isn't one out there. However, we do have Professor Cox's treatise, and everyone that practices land use law in New Jersey has this book. And Professor Cox acknowledges that while there are no unpublished or published cases on the subject, that in his opinion, a governing body does have the right to relax the rule. And I'm guided by Professor Cox. Now, there was the other thing that I would say is, I think that we have counsel for the applicant arguing that, you should relax the defective notice or relax the rule that pertains to notice, but don't relax the 10-day period of repose. And to me, I think as a matter of fundamental fairness, if the notice was defective, and I think that it was, because I don't think it put anyone on notice that a copy of the resolution was available in the office of the clerk, and that would trigger the 10-day notice, and that's specifically the rule set forth by Judge Winkelstein in the Island Club case. And interestingly, Judge Winkelstein cites a reported appellate division case, Toot Focus versus Joy, and that's at 81 New Jersey Super 526, appellate division 1963, that an objector's personal knowledge of a board's decision did not impair the objector's right to wait for formal publication of the notice before instituting an action for review of the decision. I think that if we look at the equities, I think you can consider the equities of the fact that Mr. Abbott's attorney became unavailable to him 5 days before I believe the Board of Adjustment adopted its resolution. So that's certainly something that you can consider. But I think you have discretion here, and then you've got to decide whether or not to exercise your discretion and grant the relaxation of the rule.
If I may, before we make any other move, I guess I'm going to be the one. When I left that zoning board meeting that night, I made it pretty clear on the front steps of this building that I was appealing that decision. And it was important enough to me that I delivered that intent to the city, to the attorney. I didn't say attorneys, because I didn't have an attorney. Never had an attorney. It was that important to me in my situation. My question is, I guess, how really important was it with the relaxing the time of actually filing this appeal? I didn't even wait. I was here, like has been mentioned, for the zoning board hearing. That's where I'm troubled with. It was important enough to me to start going right away. And I did. And I guess that's posed to Mr. Abbott's attorney. Probably wouldn't be correct to pose it to Mr. Abbott.
Can you approach the lectern, please?
You can barely hear me when I'm talking into this thing. You might not be able to hear me if I don't. If the question goes to whether Mr. Abbott feels strongly about the appeal, I can tell you that he does. We wouldn't be here otherwise. But I think that fundamental fairness, not just for Mr. Abbott, but for anyone who might be in the position to also feel strongly about whether this variance was granted, deserves the opportunity to receive proper notice of what the decision was and what the resolution, where the resolution is and what information's in it. So I don't know if that entirely answers your question, but it certainly, I don't think that it's fair to Mr. Abbott to read anything into the brief delay in filing his pro se appeal with the board, with this body of the board's decision, particularly with those procedural difficulties that he was facing, not only with the notice itself, but with suddenly being bereft of counsel.
I have another, I don't know, question statement. So the, the statement, common sense or legal arguments, legal technicalities, wouldn't common sense dictate that you would hear something on the merits and make a decision and not just on the timeline? If the timeline is, and you argue against it, please, if the timeline doesn't seem to be well established or set in stone that we can't do that, why wouldn't we proceed to the next common sense part of hearing an argument on the merits?
Well, it's that's called the doctrine of equitable tolling of a period of repose. And basically what that means is that you consider the equities. Now, I asked counsel if his client would suffer prejudice if the board entertained the late notice that was filed. I think it was filed 12 days late. Counsel may disagree with me on that. I don't think that's the kind of prejudice that you would be looking at. In other words, did that delay in 12 days create a situation where he suffered prejudice? So, for example, if he started building his building or doing something like that, that to me would be prejudice. I didn't hear any prejudice of that type. I think that's a factor. Another factor would be everybody's entitled to access to the courts and to have their day in court. And if you decide something, on a threshold issue and not on the merits, that's something that you can consider. And I think you also have to consider the issue as to notice. If the notice was defective, that certainly would be an equitable basis to allow an appeal that was filed out of time by 12 days. But it's discretionary with you as to what you're going to do. And as I said before, this issue probably is going to be revisited by Judge Telsey.
Yep.
And with the timeliness situation, that's what we're deciding here right now. We're deciding timeliness.
And if we can enlarge that timeline, correct? Is that the?
That's right, because, and the reason you're addressing that issue now, Commissioner Hewitt, is because if you find that the application is not timely, then that's the end of what we do here today. And then I think the case probably goes back to Judge Telsey. And then he'll decide, he may look at the timeliness issue different than the way that we do.
I think
in that
everybody
case,
here
or in any
realizes
case.
it.
Yeah.
I think everybody here realizes I'm troubled with timeliness and the way I was guided as a resident.
I didn't think that he was.
That,
We've had a
that's,
transcript, we've had a transcript.
that's my trouble, is timeliness.
Transcript of the court case.
I know you have it, I'm just reading the
Well,
email that we got from them.
My other question here is, it's going to refer to farther into the night. Where's the transcript of the meeting? The original zoning board meeting?
That was provided to you and to the commissioners
A while
when this
ago.
matter was scheduled previously, before the Superior Court case.
Through
was-
our email.
Yeah.
Yeah, I sort of thought maybe Mr. Abbott would supply it. I went that.
We already
I guess
have
that
it.
was my depth, you know. I supplied it up here again in written form. That was just
We-
my depth of how I did mine, that's all.
Joe, we received a written copy. I read it. Yeah.
So I guess what's left, make a motion.
You just need to make a motion on, the timeliness.
Timeliness.
There's
Whether we-
actually,
so I don't know
think
how
that-
you wanna
Well, the
pose
way I
that.
think it should be phrased, I think our future first attorney has made an application asking you to dismiss the appeal because it's untimely. So I think the motion should follow that. So yes would be a vote to dismiss the appeal as untimely. No would be a vote not to dismiss the appeal.
Make a motion as stated by the solicitor.
I'll second the motion. So we have a motion and a second to, can you restate that? Because I didn't write
Well,
all, like, just make sure. I
Mr.
have it written
Norman
down.
just stood before you, and he's asking you to dismiss this appeal. He's making an application for you to dismiss the appeal as untimely. So yes would be to grant his application, no would be to deny his application.
Actually, the appeal was filed by Mr. Abbott, and he's asking for it to be heard out of time.
Well, you have a motion, sir, so let's phrase it the way that I just placed on the record. It's Mr. Norman's motion to dismiss the appeal as untimely. So again, a vote yes is, yes, Mr. Norman is correct, the appeal is untimely. No, he's wrong, the appeal is not untimely, and that would be to deny his motion.
Okay. So you have a motion and a second. Do we need to comment, or can I just go right to
You
roll
can
call?
comment if you want.
Okay. Does anybody want to have comments?
I don't have any comment.
I'll just say this, and we talked about common sense, and I really see no harm in us hearing it. Either way, it's going back to the judge. I'm looking at the transcript from the court. The judge basically says, exhaust the administrative remedies. This will be an administrative remedy. So why should we not exhaust it? It'll be appealed either way. We're not going to have the final decision.
Correct.
That's what I think we should do. So that's my logic. Agree with it, disagree with it, but that's my logic.
May I have roll call, please?
Commissioner Hewitt?
Yes.
Vice Mayor Sui?
No.
Commissioner Watson?
No.
Commissioner Romanek?
No.
Mayor Orndorff?
No.
Okay. Motion fails.
Can we take a recess?
Now, before we get to the merits, I have a personal emergency I need to call.
Okay, can we just take a 5-minute recess, please?
About 10-minute, please.
10
Ten-
minutes.
We need a motion for a 10-minute recess, please.
Make a motion for a 10
All in
minute
favor?
recess. Aye.
Thank you. We'll be back in 10.
Now you learn just to, well, you're already way ahead of the game. Not having to be so position. I just, it didn't take me long personally. I just walk every day. Political news, search it and see it. Sometimes, but now I find it easy. Because you learn, like, you don't see it as basic.
I'm sorry. Good. Hey, thanks so much. I really appreciate it. Hey, Larry. Larry, the problem is now I'm locked out. What if she doesn't say?
Hey, Brock, did the boss get in the house? He did.
I gave up a Phillies game for this.
What's that?
Just want to return to regular order of business. Do we want to start with Solicitor? Do you want to start?
Yeah,
I don't
the
know where you
next,
wanna- The next step here.
the next item on the agenda would be on the merits, and it would be the argument of Mr. Abbott's attorney. Before we get to that, there are a couple of items of housekeeping. One is that counsel for Our Future First had addressed a letter to me and had attached audio files of certain conversations between his client, Vice Mayor Suey, and myself, and suggested that there was a conflict of interest. I disagreed with that analysis. However, I think so the record's complete. I did have a certified court stenographer or stenographic service prepare certified transcripts of all of those calls, and they are, of copies of them, I think 20 or so are available on the table there. And at the very beginning of this meeting, I gave a transcript, or a copy of the transcripts, I should say, because I think it was 3 conversations between Mr. Tom and Vice Mayor Suey, and 1 with me, and then I think 2 other ones were Mr. Suey or Mr. Tom leaving messages. So those transcripts are there for anybody that wants to review them. I'm going to attach the original to the transcript because I think, as I said before, I think this case is going to be appealed no matter what the board does. And if that issue is going to be raised, then I want the judge to be able to look at the certified transcript of those telephone calls so that that's going to be available. The second item of business, and counsel, before you start, I'm going to direct this to you. My concern with this case when I read the transcript was that the vice mayor, or the vice, excuse me, I take that back, the vice chair of the meeting, who was the acting chair because the chair was not present, was on the, or his family business, I should say, was on the 200-foot list. And that would be 10 Main Street East, Unit E. And he testified on the record that he had been working at that business, his family business, for the past 11 years. I think, under my analysis of the law, that presents a problem with that determination by the Board of Adjustment, because if there's a disqualifying conflict of interest, and there's a case right on point, care of Tenafly, which is an appellate division case, then that infected the entire proceeding before the board. The other thing that I didn't realize until today when I was preparing, that I believe, I don't know for certain, that the board attorney may have also been on the 200-foot list, because I see a notice went out to Red Corn Inc., I don't know who that is, at 21 East Main Street. So, that would pose a concern. Now, obviously, there's 3 things that the governing body can do on one of these appeals. One is you can affirm the decision of the Board of Adjustment, which would mean that the use variance would stand. The second thing you can do is you can find on your own, you don't have to find that there was any error, but you could determine based on the record that the variance should not have been granted and deny that. And the third thing that you are entitled to do under the municipal land use law is you can remand the case back to the Board of Adjustment to conduct a rehearing. Now, given the fact that there's at least one very substantial conflict here, I'd like to hear from counsel as to his view on whether or not this has to go back to the Board of Adjustment.
Well, I think with respect to any remand back to the Zoning Board of Adjustment, is the vice chairman still a member of the Zoning Board today?
No.
No. And the solicitor isn't either.
Well, that it certainly raises concerns with respect to the integrity of the entire proceeding below.
Because, not to interrupt you, but the problem with this, even if we had chosen to grant the motion that was made by Mr. Norman, this goes up to Judge Telsey, at least as a prerogative writ appeal, And I don't see what choice he would have but to send it back to the Board of Adjustment.
Could we read that statement that the vice chair of the zoning board made? So everybody has an understanding of what it is? Or
I
could
will
read
do
it if you have a
so.
copy of it.
Give me a second. And I don't want to embarrass him. I think he's a smart guy and he's an honorable guy, but he's not a lawyer. And he probably didn't realize that there would be a problem because the notice went to his father, not to him. And I'm reading from the transcript, and this is on page 70, line 12, and it's the vice chair. It says, "Thank you. I think I closed the public portion. If not, the public portion's closed. I bring it back to the board for finding of fact. I know it's late. I appreciate everybody's patience with this. I would like to get some discussion, debate amongst the board. I've worked across the street from this building for 11 years, so I'm familiar with what's happened in the last decade. I can attest to, the vandalism, the homelessness. I think people at one point were squatting in the building, so me as his name, would love a gastro pub there because I work across the street, but as a zoning board member, have to be realistic and look at the application that's before us." So, and if I got the 200-foot list, and I see a notice went to the owner of the business, his father, where he's worked for 11 years. It's an insurance agency, and it is directly across the street from the subject property. So. The other thing is this, the case I referred to earlier, and it's the Care of Tenafly case, which is an appellate division decision, 307 New Jersey Super 362, and that was a 1998 case, and that case involved a planning, I think it was a zoning board member in that case. His mother was the owner of a commercial property located directly across the street from an A&P project. And he did not disqualify himself, but voted on that particular application. And that was held to be a disqualifying conflict of interest. It didn't matter if there were enough votes to approve the application in the absence of his vote. The court held that the fact that somebody that had a conflict of that magnitude infected the whole process. So it would seem to me that it would be appropriate to remand this back to the Board of Adjustment in order to correct or to prepare an entirely new record that would be free of any conflict. And then at that point, the parties can do what they want. Somebody might take an appeal, but at least it's better than the case going to Judge Telsey and then going back to the board, which could add another 4 or 5 months to the process.
So rather than hear this entire argument and then vote to remand or not to remand at the end, I think we should probably.
Well, I think we need to
do
hear
that
from all
now, or
the
you
attorneys
gotta hear
first
first?
before we do anything,
Okay.
but that would be my inclination. So if council would, sir, I don't know if you're done or not, if you would restrict your comments to the conflict issue, and then we'll hear from the other two attorneys, and then the board can decide what it wants to do at that point.
Certainly, thank you, Solicitor Russell. I'm not familiar with the Tenafly case that you cited, but if it says what it says, you say it says, which I have no reason to doubt that it doesn't, then I believe a remand to the zoning board is appropriate. I think that Vice Chair Connor's comments certainly arguably rise to the same level of disqualification that may have been present in the Tenafly case. So I'll restrict my comments to that. I have no problem with a remand to the zoning board.
Mr. Norman?
Well, first off, this is new evidence, which was not part of the record or below, so I was not really prepared to address it. That's a due process thing. That's my concern is I'm just hearing it for the first time that supposedly a zoning board member's parent owned property within the 200-foot list. never came up. It was not in the pleadings before Judge Telsey.
Could you reread what,
I'm not going to reread it, but
but doesn't it say that he has a business there or something right across the street?
he did. He said, but a conflict is not waivable. So if there's a conflict, it can be raised at any time. It can be raised for the first time in Superior Court, and it probably will be raised in Superior Court if the record isn't corrected and it doesn't go back to the Board of Adjustment. And by the way, if it goes back to the Board of Adjustment, everybody gets to be heard, unlike this proceeding where, you know, we're limited to what's in the record.
Like I said, I'm a little,
Well,
I haven't had a chance to read the Tenafly case, so like I said, I feel a little hamstrung.
I can understand that, but I can also understand you have a copy of the transcript.
And the notice of who received the 200-foot notice and the board members.
Yeah, and he kind of says,
And he says he works
As
within.
as I heard the transcript as your solicitor read, I work there is a little different than saying I own property.
his father owns the business.
His father owned the property. He did, that wasn't on the transcript. That, I believe that was done through,
Okay, I
believe
understand where you
the
didn't catch it.
solicitor said he did some extraneous research.
Okay, I can understand why you wouldn't know
Outside
that.
the record, so it was
I
not.
can understand where you wouldn't know that.
It's, yeah, there was no
our-
way to know that.
Well, that-
However, our solicitor should have known that if,
Months.
should have advised him.
Well, it is, the one property of Mr. Connor is on the 200-foot list. And the other, there's another property there, 21 East Main Street, which is also on the 200-foot list.
Do we need another recess for the attorney to speak with his client about this for a short amount of time?
10 minutes?
That's fine, we'll make a motion for a 10-minute recess so
Make
the
a
attorney
motion?
can,
Second the motion.
all in favor?
Aye.
Thank you.
Chris,
Thank you.
I'll give you a Tenafly too. Here is the. I'm going. Larry calling me 10 times, and now you're trying. I told Larry, I said, Larry, I said, now I'm locked down. I said, I might need to sleep on your sofa. And I said, actually, since I didn't take my wife's calls for 10 minutes. I guess she has a dog too.
Oh, took the dog out for a walk and locked herself out.
I guess they're in the car listening to the radio. She's in the house, isn't she? Excuse me? Is she in the house? No, she quit. She is now. She was.
Oh, she was waiting for you to answer the call?
Yeah. I'm so in distress.
All ready? Everybody good? Counsel, you ready?
I'm ready.
Solicitor? Brock? Good?
Yeah.
Okay. Well, on a proceeding under Section 17 of the Land Use Statute, it's supposed to be based on the entire record before the zoning board. The new evidence I heard tonight, which we have had no opportunity to investigate or rebut, is outside the record, and I believe you cannot consider it in accordance with the statute because it's outside of the record, first. And secondly, in the first go-around when we talked about the 10-day appeal period, the theme I heard was this case is going to the court anyway, regardless of the outcome. So we should hear the appeal. And my argument is yeah, if we're gonna, if that's the way you're looking at this appeal, you should hear this appeal on the merits tonight and render a determination and let the chips fall as they may on any appeal in the Superior Court or any other court. And also, there's also a conflict allegations which are outside the record, which I wasn't going to raise tonight because they're not part of the Section 17 statute, which was sent on August 14th. Those are issues of conflict. I could have raised the issue of Commissioner Soy and your solicitor participating. I did not do that because I wanted to follow the statute. If those conflict issues come into question in litigation, well, maybe your decision on the 10-day is no good because that was tainted by a conflict of interest. So I think that if you want a neat package where you get a full decision on the merits, we go ahead with it. The parties reserve their rights to raise any conflict issues. If it does go to court, let the judge make the call on that. And that's our position.
So good evening. With respect to the record below, jurisdictionally, the issue of whether notice of the application is made is a jurisdictional issue before the zoning board. And the applicant is required to show proof of publication and proof of service. And the service list includes the 200-foot list. And that's all part of the record. So that was part of the record below, and it was part of all the documentation before the zoning board. The fact that nobody picked up on it until perhaps recently doesn't mean it wasn't part of the record below. With respect to the potential conflict of a voting member, if they personally were within the 200-foot list, they should not participate. They should recuse themselves. If they had a close personal family member, not the fourth cousin of the sister-in-law of the brother of the neighbor once removed, but somebody who is a parent in a family-run business, that would appear to me to be something that would require recusal. With respect to counsel, the solicitor for the zoning board, or even here, solicitors are not voting members. So generally, they're not deemed to be requiring recusal. There are some instances where some solicitors may feel that they lead the board a great deal, or they make certain comment, but that doesn't govern. I'm not aware of reported decisions where solicitors have to recuse themselves for personal interest, but so be that as it may. But the board member, that was all part of the record below.
Thank you.
What I would recommend is you determine, well, you can go on and have an entire hearing if you want, or you could vote as to whether or not the conflict requires this to be sent back to the Board of Adjustment. I mean, if that's what you're going to do, there's no point in hearing the case on the merits.
Yeah, if there's a conflict and if there's a conflict and it's null and void, if that's
Well, it's not
Not
null and void, but
but-
it's voidable, it's non-waivable, it can be raised at any time, and in my view, it infects the record, and that's what we're looking at, is a record that I think is defective, and I think you need to have a record that doesn't have the taint of a conflict of interest, and I would disagree a little bit with Ms. Gordy. I think that if you're an attorney and your property's within 200 feet, and I'm not 100% sure that his is, so, but if that's so, I would have a problem with that. But certainly, there's no issue as to Mr. Connor having a conflict.
No, I think it's pretty much undisputable that Mr. Connor had the conflict. He basically said exactly what that case law said.
his statement provided, how would
Yeah,
it
and
benefit
in the
his
tra-
business?
It's in
Well,
the transcript.
If you read the cases, and then there's the Wisakowski case, which is a Supreme Court case, and really the way the court kind of distills it down to its essence is, does the board member have a special interest in something as an interest that's different than just a general member of the public? So obviously, if I live across the street, I don't like the way the property is because it's been vacant, and I want somebody to occupy it. That's an interest that you have that's different than the public, and you should step down.
Well, I don't know what you guys think, but I'll make a motion to remand it to the zoning board.
All right, so there's a motion to remand
It
it.
would be reverse the decision of the Board of Adjustment and to remand it back to the zoning board for a rehearing based on the conflict of interest.
There you go.
A second?
My question would be to the city solicitor, are we again just prolonging the inevitable of being back to the Superior Court?
Well, you know, I'm not so sure this interest goes away. You know, it could be raised again in Superior Court. So I think it may actually save time for the applicant.
Right, so the
Goes
way,
back to the
so
board.
sorry to cut you off, so the way I'm seeing it is, if we decide to make a decision on this tonight, no matter what our decision could be, it's still most likely going to go to Supreme Court because of the conflict of interest.
Well, it's gonna go to the Superior Court, I
Superior Court,
think,
sorry.
because whoever loses is going to appeal, no matter what you do. And even though you'd be making a new decision, you're still making it based on a record that's tainted. So, I don't know that the conflict of interest issue would go away. And I think in the first instance, the Board of Adjustment should be hearing the case and not the governing body. Now, depending upon what they do, if there's a right to an appeal, then we hear it at that point. But it seems to me the conflict of interest is certainly a clear one. I think it affected the proceeding, and in my view, I think it would be appropriate to remand the case, but, you know, you have to make your decision.
So we have the motion.
Second motion.
There's a motion and a second to remand this back to the zoning board
To reverse the
the decision
and to
and to have
remand.
remand it. Okay. Do we have any comments? Just go right to roll call then.
Commissioner Hewitt,
Yes.
Vice Mayor Sui.
Yes.
Commissioner Watson.
Yes.
Commissioner Romanek,
Yes.
Mayor Orndorff.
Yes.
Okay, motion carries.
Chris, can I have that mailing list? If you want a copy of that, I can send it to you. Yeah. And you can have the Tenafly case.
Motion to adjourn.
Make a motion.
All in favor?
Aye.
Aye.
Aye.